This section examines how jury nullification operates in contemporary practice, focusing on key areas where judicial, legislative, and public interests intersect. First, it surveys current judicial positions, revealing how many courts discourage explicit reference to nullification while acknowledging its tacit power. Next, it explores state-specific variations in jury instructions, highlighting differing approaches to guiding or limiting jurors' moral discretion. The section then assesses how nullification impacts sentencing outcomes, especially under mandatory guidelines. Finally, it delves into emerging discussions regarding whether jury guidance should be broadened to ensure transparency or curtailed to preserve consistency and respect for existing statutes. Jury nullification and judicial systems. In the preceding sections, we traced the evolution of jury nullification from its historical roots through various philosophical, legislative, and cultural developments. We now arrive at its modern context, the contemporary judicial framework, and how today's courts, lawyers, and jurors navigate the complex realities of conscientious acquittal. Although the principle remains an integral but understated aspect of Anglo-American jurisprudence, its actual practice has become more guarded over time. By examining judicial attitudes, jury instructions, voir dire practices, prosecutorial and defense strategies, and the interplay with sentencing regimes, we come to understand why jury nullification continues to spark debate among legal professionals and the public alike. Contemporary judicial attitudes. Modern courts tend to treat jury nullification with a degree of ambivalence. On one hand, the principle is implicitly recognized. Courts generally concede that jurors cannot be punished for acquitting a defendant, even if evidence strongly indicates guilt. On the other hand, judges and appellate courts often emphasize that jurors are duty-bound to apply the law as instructed. In practice, this duality means that while nullification remains a legal possibility, judges typically avoid informing juries about it, and indeed many explicitly forbid attorneys from urging jurors to disregard the law. Over the last few decades, multiple rulings in various jurisdictions have upheld this stance. Judges often cite concerns about consistency in applying statutes and about the potential for biased or arbitrary verdicts. Yet, the underlying acknowledgement persists. A not guilty verdict, no matter how legally questionable, is final and unassailable. This tacit acknowledgement of the jury's ultimate power coexists uneasily with the official judicial position that the jury must follow legal instructions. Some critics argue that this contradiction creates a confusing environment in which jurors may sense they have moral leeway but lack clarity on how to act upon it. The scope of jury instructions. A central point of tension revolves around jury instructions. What exactly should judges tell jurors regarding their role? In most jurisdictions, standard instructions focus on the elements of the crime, the relevant definitions, and the requirement that jurors determine if the evidence meets the burden of proof. Typically absent is any explicit statement that the jury may judge the fairness or appropriateness of the law itself. Defense attorneys who attempt to introduce arguments about conscientious acquittal often face judicial rebuke, and in some cases, judges have issued mistrials or sanctions for attorneys who broach the subject too openly. Reform-minded critics suggest that juries deserve full transparency about their legal power, or at least an acknowledgement that they can acquit when application of the law would violate their conscience. Supporters of the status quo counter that explicitly encouraging nullification might lead to unpredictable verdicts and an erosion of public confidence in a uniform legal system. This debate persists in legislative efforts within certain states, where activists occasionally push for jury rights bills that would mandate instructions on nullification. Thus far, such reforms have faced significant resistance from courts concerned about turning what they see as a rare, exceptional mechanism into an open invitation for jurors to second-guess every statute. Voir dire and jury sélection. A practical mechanism through which modern courts control or limit nullification is the jury selection process, known as voir dire. During voir dire, attorneys and the judge question prospective jurors, ostensibly to uncover biases or predispositions that might prevent them from rendering an impartial verdict based on the evidence. However, in many jurisdictions, any whiff of an inclination toward nullification can lead to a prospective juror's dismissal. If a juror openly states they believe certain laws are unjust or indicates they would prioritize personal conscience over written statutes, prosecutors, and sometimes judges frequently move to strike that individual for cause. This screening process underscores attention. The system nominally values independent juror judgment, but it also attempts to weed out those who might intentionally use nullification to defy the law. Some defenders of the practice argue that rigorous voir dire is necessary to protect the court's legitimacy and ensure the jury pool can apply the law in a consistent manner. Yet critics maintain that probing a juror's moral beliefs too aggressively tilts the field against conscientious acquittals, effectively stacking the jury with individuals more inclined to follow instructions without question. As a result, modern voir dire often becomes a gatekeeping tool that shapes not just who sits on a jury, but the likelihood that nullification might emerge as a meaningful option in deliberations. Prosecution strategies. Prosecutors generally approach jury nullification with caution, aiming to present the state's case in a way that minimizes any perceived moral ambiguity. If the charges involve a controversial law, such as a nonviolent drug offense with a harsh mandatory sentence, a savvy prosecutor might downplay sentencing consequences or emphasize the alleged harm to victims or the community. In doing so, the prosecutor hopes to forestall any juror empathy that might lead to a nullification verdict. Moreover, in certain high-profile cases, prosecutors may request the judge to deliver stern instructions, reminding jurors to follow the law strictly. In jurisdictions where judges allow it, the prosecution may directly question prospective jurors about their willingness to convict despite moral qualms. Tactically, prosecutors are aware that if jurors suspect injustice in the law or the prosecution's approach, they could use nullification to thwart a conviction. Consequently, the prosecution's objective is to frame the law as reasonable and the facts as unequivocally damning, so that nullification becomes less appealing. Defense tactics. From the defense perspective, the question of how to handle nullification is fraught. Openly advocating for it can provoke judicial sanction or even a mistrial. Therefore, many defense attorneys resort to subtlety. They may highlight the unfairness of the law or the harshness of potential sentences without directly telling jurors to ignore the judge's instructions. They may stress the defendant's personal circumstances, e.g., health issues, family obligations, or the nonviolent nature of the alleged conduct. Such narratives aim to plant a moral seed, nudging jurors to consider whether strict enforcement of a law truly serves justice. In certain cases where public sentiment strongly favors the defendant, for instance, an individual facing severe penalties for an act widely seen as altruistic, defense counsel might weave moral arguments into closing statements, focusing on empathy and the principle of fundamental fairness. However, even these mild allusions can draw quick objections from the prosecution or stern warnings from the bench. Hence, many defense lawyers find themselves walking a tightrope. They must convey the moral stakes of the case without openly inciting the jury to disregard the law. High-profile and controversial cases. In high-profile trials, the possibility of nullification can loom large, particularly if the defendant's alleged crime intersects with a significant social issue. Political protest, whistleblowing, civil disobedience, or medical marijuana are common examples. When media coverage is extensive and public opinion is polarized, the courtroom becomes a stage where broader ideological clashes are played out. Jurors, aware that their verdict carries symbolic weight, may feel more emboldened to consider nullification if they perceive an injustice in the way the law is enforced. One illustrative scenario involves cases tied to drug policy. In states that have legalized or decriminalized marijuana to some extent, but where certain federal or residual state laws remain harsh, defendants can find themselves facing serious charges that many in the community view as outdated. In such circumstances, a jury might quietly decide to acquit despite evidence of technical guilt, effectively sending a message that the community does not support punitive measures for a given conduct. Conversely, in areas with conservative attitudes or heightened concerns about drug use, the same case might lead to a straightforward conviction. These divergent outcomes highlight the persistent influence of local community sentiment in shaping how and whether laws are enforced through trial by jury. Sentencing implications. The rise of mandatory minimum sentences and three strikes laws over the last several decades has reinforced certain arguments for nullification. When a conviction automatically triggers a draconian punishment disproportionate to the severity of the crime, some jurors, upon learning about these sentencing realities, may balk at convicting. This reaction can emerge in offenses such as low-level drug possession or minor theft under three-strike statutes. Although many judges try to shield jurors from knowing specific penalty ranges, word can still leak through pretrial publicity, attorney hints, or simple common knowledge. Simultaneously, harsh sentencing laws can also discourage nullification by portraying the defendant as inherently more culpable or untrustworthy in the eyes of the jury. Prosecutors sometimes emphasize prior offenses or the seriousness of the penalty to convey that the defendant is a persistent lawbreaker, deserving of stiff consequences. This interplay underscores that mandatory sentencing provisions do not just shape post-verdict penalties. They can also tilt the psychological landscape in which nullification might arise. Juries torn between empathy and fear of releasing a serial offender face a moral quandary at the heart of which sits the question: should we follow the statutory path or heed our own sense of proportionality? Ethical and professional considerations. Lawyers and judges operate under strict ethical standards, which can complicate discussions of nullification. A defense attorney who overtly encourages jurors to violate the judge's instructions risks accusations of unprofessional conduct. In several jurisdictions, bar associations caution lawyers not to argue nullification explicitly, leaving it to jurors to discover that option themselves if they are so inclined. For prosecutors, the ethical dilemma is less direct, yet they must still walk the line between zealously advocating for conviction and respecting the defendant's rights. A prosecutor who pressures a judge into disqualifying any potential nullifiers during voir dire might face criticism for undermining the spirit of an impartial jury. Judges, too, wrestle with ethical obligations. They are charged with maintaining the integrity of the trial, ensuring that verdicts are based on evidence and law rather than personal bias. However, if a judge notices that a jury seems poised to nullify, there is little they can do beyond reiterating instructions or, in extreme cases, declaring a mistrial if the jury's discussions become overtly contrary to legal process. These ethical tightropes illustrate how modern judicial systems strive to balance the unfettered power of the jury with procedural norms designed to uphold uniformity and fairness. International comparisons and emerging trends. While jury nullification is most commonly associated with Anglo-American legal systems, it is not wholly absent elsewhere. Some countries, like Canada, share a similar heritage and thus confront parallel issues, though Canadian courts generally provide narrower openings for nullification discussion. In contrast, many civil law jurisdictions, e.g. in Europe and Latin America, employ more inquisitorial procedures with professional judges playing a dominant role in fact-finding. This setup significantly reduces the scope for nullification, as juries, if they exist at all, often lack the same tradition of independence. Still, global conversations about participatory justice increasingly engage questions about whether citizen judges should have moral discretion to overrule statutes they deem unjust. In the United States, an emerging topic is the role of digital communications and social media in shaping juror attitudes. Modern jurors can find information on sentencing guidelines, political debates, or prior nullification cases at the click of a button, though such independent research is forbidden in most court rules. This flood of easily accessible knowledge, combined with widespread online debate about the moral dimensions of criminal statutes, suggests that nullification concerns may only intensify. Courts have struggled to police juror internet use, raising the possibility that more jurors will enter deliberations already aware of their power to nullify. Balancing law and conscience. In sum, the current legal framework surrounding jury nullification is marked by tension at every level, from how judges instruct juries, to how prosecutors frame their cases, to how defense attorneys seek moral sympathy, and how legislatures design sentencing guidelines. Although the principle itself remains a silent cornerstone, jurors can always deliver a final acquittal. The system often strives to contain, if not wholly deny, that power. The net effect is an environment in which nullification is rarely named outright, yet always a possibility should a jury's collective conscience disagree with the written law. Looking to the future, several factors will shape jury nullification's trajectory in judicial systems. Ongoing disputes about criminal justice reform, including the scaling back of mandatory minimums, may lessen the impetus for juror revolt against perceived excessive penalties. Conversely, political polarization and the emergence of increasingly rigid or controversial laws could heighten the likelihood that some communities will reject what they view as oppressive legislation. Furthermore, technology's role in informing, and sometimes misinforming, jurors about their prerogatives underscores the importance of clear judicial guidance. Whether that clarity involves acknowledging nullification explicitly or further restricting any mention of it is a question that courts, lawmakers, and civic advocates continue to debate. Ultimately, jury nullification remains a testament to the role of conscience in the law. As much as modern courts strive for consistency and predictability, the human dimension of justice cannot be fully excised. The principle endures because it reflects a deeper philosophical truth. Laws exist for the people, and if those laws clash too severely with widely held moral convictions, people, through the jury, retain the power to push back. In the next chapter, we will delve more deeply into how social movements and public perceptions interweave with the notion of nullification, examining the extent to which community activism, political discourse, and evolving moral norms affect how frequently jurors opt for conscientious acquittals. By understanding these broader societal forces, we gain a richer appreciation for the enduring, if carefully contained, power of everyday citizens to shape the course of justice. Jury instructions and legal boundaries. In the previous chapter, we examined how jury nullification fits into modern judicial systems, surveying judges' ambivalent attitudes, prosecutors' and defense attorney strategies, and the role of voir dire in shaping the potential for conscientious acquittals. Now we turn our attention more specifically to how jury instructions, those pivotal communications provided by judges, operate as both a practical and philosophical boundary in trials. These directives, carefully crafted and periodically revised, profoundly influence whether jurors even realize they have leeway to acquit despite evidence of technical guilt. By exploring the evolution of jury instructions, the variation among jurisdictions, and the interplay between legal mandates and jurors' moral judgment, we uncover why instructions remain a central battleground in the debate over jury nullification. The purpose and evolution of jury instructions. Jury instructions serve as the structural frame through which laypeople, often inexperienced in legal matters, are guided to deliver a verdict. They typically outline the elements of the crime charged, define key legal terms like reasonable doubt or mens rea, and explain the burden of proof. Over time, these instructions have grown longer and more complex, reflecting both the diversification of criminal statutes and a broader concern that jurors fully understand the technicalities of the law. At their core, however, instructions fulfill two fundamental objectives: to educate jurors on how to apply legal standards to facts, and to preserve defendants' constitutional rights by preventing arbitrary decision-making. Historically, jury instructions were relatively brief, often delivered orally by the judge in an extemporaneous manner. As the American legal system matured, appellate courts recognized inconsistencies and errors in such ad libitum directives, which could lead to wrongful convictions or unfair acquittals. To address these inconsistencies, states and federal courts began adopting standardized or pattern instructions for common criminal charges. These model instructions, developed by judicial committees, aim to ensure uniformity across a given jurisdiction. At the same time, they are sufficiently adaptable to accommodate specific case facts. Yet, amid these efforts toward clarity and standardization, explicit references to jury nullification are conspicuously absent in most pattern instructions, excluding nullification, the official stance. Why are references to jury nullification not found in standard instructions? The dominant rationale is that courts fear undermining the principle of consistent law enforcement by appearing to condone jurors' power to disregard the law. Judicial precedent in many jurisdictions holds that while nullification is an undeniable possibility, it is not a right for attorneys or defendants to invoke openly. Courts consistently rule that no party has a legitimate entitlement to a nullification instruction, as judges often describe it. In other words, a defendant cannot demand that the jury be told, "You may acquit if you believe the law is unjust." This exclusionary stance stems from several concerns. Uniformity and predictability. Courts worry that highlighting nullification would produce inconsistent outcomes, as certain juries might apply the law strictly while others might rely on personal values or community norms. Risk of bias or prejudice. Explicitly permitting nullification could open the door for discrimination-driven acquittals, mirroring historical episodes when racially motivated juries refused to convict white defendants for crimes against minority victims. Judicial integrity. Judges typically present themselves as neutral arbiters of the law. A direct acknowledgement of the jury's power to override statutes could be construed as a judicial admission that the law can be selectively enforced. Thus, while a jury's general duty to follow the law as given remains the official standard, the power to nullify resides in a hazy moral space that is seldom delineated for jurors. The legal boundaries of instructions. Within the broader purpose of maintaining the rule of law, jury instructions delineate a series of boundaries: what jurors should consider, what they must not consider, and how they are to weigh various forms of evidence. These boundaries function as guardrails, ostensibly preventing the jury from straying beyond the factual question of guilt or innocence into territory where they evaluate the justness of legislation. For instance, judges commonly instruct jurors not to speculate about punishment or to rely on sympathy or prejudice. By confining jurors to an evidence plus law framework, the court attempts to ensure that each verdict rests on a standardized process rather than purely moral judgments. Two particular boundaries often emerge as flashpoints for debate: mandatory instructions on specific elements of the crime. If the defendant's actions meet the legal elements, the instructions generally say jurors must or shall convict. Critics contend that such language implies that jurors have no discretion, although legally they do. Prohibitions on outside information. Modern instructions frequently prohibit jurors from conducting their own research, discussing the case with outsiders, or consulting media. While these prohibitions serve to keep the jury's focus on evidence presented in court, they also limit exposure to broader ethical or social questions that might influence a nullification decision. By affirmatively ruling out certain considerations, instructions narrow the lens through which jurors evaluate a defendant's fate. This narrowing is typically justified under the rationale that it preserves the defendant's right to a fair trial, untainted by extraneous factors. Yet it also makes it less likely that moral or policy-based objections to the underlying law will surface during deliberations, at least openly. Variation among jurisdictions. Despite the generally consistent refusal to endorse nullification, jurisdictions differ in the specificity and tone of their instructions. Some state courts use more forceful language than others. For example, strict admonitions. In certain jurisdictions, instructions remind jurors they are not to consider or discuss any possible sentences, and that they must apply the law as it is given. Such instructions leave virtually no space for moral or conscience-based decisions. Softer guidance. In other jurisdictions, the instructions might adopt more measured language, indicating jurors must consider the facts carefully and render a just verdict, without overly emphasizing strict obedience to the letter of the law. Although still not openly inviting nullification, these milder directives may give jurors a subtle sense of agency in shaping the verdict. At the federal level, standard pattern instructions similarly avoid acknowledging nullification. Federal judges typically direct jurors to decide the case based solely on evidence and law, reminding them that it is their duty to do so. Unsurprisingly, This consistency stems from the federal rules of criminal procedure and a robust body of appellate case law discouraging any explicit mention of nullification. Meanwhile, at the state level, statutes regarding sentencing, guidelines for statutory interpretation, and local legal culture can add further nuance to how judges craft their instructions. Some states allow more flexible language, particularly in certain defense-related instructions where moral or equitable issues, e.g., self-defense or necessity, may come into play. Defense attempts to introduce moral context. Despite the official prohibition, defense attorneys sometimes push the boundaries in hopes of planting seeds for potential nullification. They might, for instance, request a jury instruction on the moral imperative behind a defendant's conduct if the case involves civil disobedience, whistleblowing, or other socially resonant issues. More often than not, judges deny such requests, ruling them irrelevant or unduly prejudicial. Still, defense lawyers can try subtle strategies. Emotionally resonant testimony, calling witnesses who testify about the defendant's good character or personal struggles, thereby inviting jurors to empathize. Emphasis on prosecutorial overreach, suggesting that the charge is disproportionate to the alleged harm caused by the defendant's actions, nudging jurors to question the law's fairness. If these strategies do not overtly violate the judge's instructions, they may still succeed in prompting some jurors to consider a conscientious acquittal. However, if a defense lawyer moves too boldly and references nullification outright, the prosecution may request a mistrial or sanctions, asserting that the defense aims to lead the jury to disregard the legal boundaries set by the court. The conundrum of sentencing awareness. An additional arena where jury instructions and legal boundaries intersect is sentencing information. Many judges prohibit any mention of sentencing outcomes, barring references to minimum or maximum penalties, potential enhancements, or the collateral consequences of a conviction. This prohibition aims to prevent jurors from basing their verdicts on sympathy or opposition to a harsh sentence. Yet, in practice, this separation can have unintended consequences. When jurors realize after rendering a guilty verdict that the defendant faces decades in prison for what they perceived as a minor offense, some express remorse and declare they would have voted differently had they known the penalty. Consequently, activists pushing for greater transparency argue that jurors should be allowed to know potential sentences so they can reach a morally informed verdict. Opponents counter that sentence considerations belong to judges or legislatures. Bringing punishment into the jury's purview invites inconsistency, emotionalism, and potential nullification. Thus, the boundary remains firmly in place in most courtrooms, further illustrating how jury instructions confine the scope of juror decision-making to the evidence and statutory elements alone. Appellate review and model instructions. When a conviction is challenged on appeal, defense attorneys sometimes argue that the trial court's instructions were overly restrictive or improperly biased against the possibility of acquittal. In rare instances, appellate courts have reversed convictions on the basis that instructions misstated the burden of proof or improperly shifted a presumption to the defendant. However, no appellate court has mandated that trial judges must inform jurors about nullification. Instead, courts typically reinforce the principle that while a jury may acquit against the evidence, the defendant has no right to instruct jurors to do so. In this environment, committees that draft model jury instructions walk a tightrope. They strive to produce guidelines that pass appellate muster by preventing confusion or misapplication of the law. Yet they also avoid any hint that jurors might have discretion beyond the letter of the law. In effect, the model instructions shape not just the immediate trial outcome, but the entire appellate landscape, reinforcing a tradition that frames nullification as a silent, unacknowledged power rather than an endorsed feature of the judicial system. Philosophical and ethical dimensions. Beneath the technical details about instructions and case law lies a broader philosophical conversation. If a jury truly is the conscience of the community, should it not be allowed, and even encouraged, to consider moral questions explicitly? Proponents of open recognition point to moments in history when juries refused to enforce what were later deemed egregiously unjust laws, from fugitive slave statutes to prohibitions on certain forms of free speech. They argue that instructing jurors about nullification would restore the communal conscience element to a system that often feels detached from the moral sentiments of everyday citizens. Skeptics counter that openly empowering juries to override laws invites chaos, for it leaves criminal liability to the unpredictable moral compass of local populations. In particular, they highlight the potential for discriminatory acquittals, political manipulation, or undue focus on a defendant's sympathetic circumstances rather than objective guilt. From this vantage point, instructions that constrain jurors to fact-finding and the written law are a protective measure, ensuring fairness and uniform application across diverse communities. Trends and future developments. Recent decades have seen occasional legislative or grassroots efforts to reform how jurors are instructed. Advocacy groups in a handful of states have pushed for jury rights bills, calling for explicit instructions that jurors may acquit if they believe enforcement of the law in a particular case would be unjust. Generally, these efforts have not gained widespread traction, often meeting fierce resistance from prosecutors and judicial associations, who label them as threats to the rule of law. Meanwhile, technological changes have spurred new debates about whether jurors can discover nullification on their own through internet research or social media commentary. Courts have responded by tightening instructions about not consulting external sources or discussing the case online. Whether future reformers will successfully challenge these boundaries remains uncertain, but the tension between transparency and predictability in jury trials is unlikely to subside. As moral questions regarding punishment, privacy, social justice, and civil liberties continue to surface, the battleground over how jurors are guided will remain central. Jury instructions and legal boundaries stand as a crucial fulcrum in the contemporary debate over jury nullification. While instructions primarily aim to ensure consistency, fairness, and adherence to statutory law, they also operate as a kind of gag order on the jury's moral autonomy. This legal scaffolding, reinforced by precedent and legislative inertia, keeps nullification in the background, an unspoken yet ever-present possibility. Moving forward, the extent to which jurors understand and wield their latent power will likely hinge on factors beyond the official instructions, such as public discourse, civic education, and the cultural climate surrounding controversial laws. In the next chapter, we will explore the role of social movements, media, and grassroots activism in either amplifying or attenuating the possibility of nullification. By delving into these broader societal influences, we can better appreciate how a formally contained doctrine persists as a focal point of debate, illuminating enduring questions about the dynamic between written law and moral conscience. Prosecutorial and defense strategies. In the previous chapters, we explored how jury nullification fits into the modern judicial framework, particularly by looking at judges' ambivalent positions on informing jurors of their latent power and at the strict boundaries set by standardized jury instructions. Now our focus turns to the two principal adversarial forces within the courtroom, prosecutors and defense attorneys. Although they operate under a common legal system, these actors often stand at opposite poles regarding how to handle, invoke, or conceal the possibility of conscientious acquittals. By examining their respective strategies, both explicit and implicit, we gain a deeper understanding of why jury nullification persists as a subdued yet powerful undercurrent in American trials, revealing the dynamic interplay between legal doctrines, courtroom tactics, and jurors' moral sensibilities. The prosecutor's role and objectives. The prosecutor's job is to represent the state or federal government and ensure that laws are enforced. In criminal trials, this duty translates into proving the defendant's guilt beyond a reasonable doubt. While the overarching goal is straightforward, prosecutors face a subtle challenge when it comes to potential jury nullification. They must secure convictions under applicable statutes while contending with the reality that jurors might rebel if they view either the statute itself or its enforcement in a particular case as unjust. Emphasizing the rule of law in jurisdictions where the concept of jury nullification occasionally surfaces, prosecutors often foreground the importance of respecting legal standards as they present their cases. Their arguments and evidence typically emphasize a point-by-point alignment with statutory elements, weapon possession, drug quantity, the defendant's intent, and so forth, thereby framing guilt as a straightforward conclusion rather than an open-ended moral choice. By portraying the law as a neutral framework designed to protect community safety, prosecutors strive to reduce the emotional or ethical dimension that might inspire jurors to nullify. Preemptive strike. Jury selection before the trial even begins. Prosecutors can use voir dire to identify and strike potential jurors who express misgivings about the law in question. If someone openly admits they might disregard a statute if they believed it was unfair, the prosecutor is likely to request the juror's removal for cause. This strategy helps shape a panel more inclined to follow the judge's instructions faithfully. Although defendants and courts have a say in who is excused, prosecutors wield considerable influence through their questioning, aiming to minimize the risk of an unpredictable or sympathetic juror. Highlighting victims and harm. Another tactic is to highlight the tangible harm allegedly caused by the defendant. If a prosecutor can vividly depict how the crime impacted real victims or society at large, jurors may feel a moral imperative to punish wrongdoing rather than critique the law itself. For example, if the defendant is charged with distributing illegal drugs in a school zone, the prosecutor might emphasize child safety, pushing jurors to see enforcement as protective rather than punitive. By centering the narrative on harm, the prosecution strengthens the sense that conviction is the most just outcome. Prosecutorial approaches in controversial cases. Certain high-profile or socially contentious cases, such as those involving political protest, whistleblowing, or medical marijuana, pose unique challenges for prosecutors. Here, the likelihood of jury nullification can be greater, because jurors may sympathize with the defendant's moral stance or question whether the law is keeping pace with contemporary values. Downplaying moral or political context. When a defendant's actions have a moral or political dimension, the prosecution may try to narrow the focus to the objective facts of the alleged offense. Rather than dwell on the broader social or policy implications, prosecutors frame the case as a matter of clear, rule-based violation. This approach attempts to keep jurors from engaging with the defendant's larger message or from questioning whether the law aligns with modern ethical standards. Leveraging judicial instructions in such controversial matters, prosecutors often request firm jury instructions, reinforcing that jurors must follow the law as given. They may submit proposed language, sometimes called special instructions, that emphasizes obedience to legal statutes, underscoring that the jury's role is limited to assessing factual guilt. By leaning on these instructions, the prosecutor places moral or policy critiques outside the scope of deliberations. Public sentiment and media. When public opinion might tilt in favor of the defendant, prosecutors confront the possibility that jurors bring sympathetic biases into the courtroom. Consequently, prosecutors try to control the media narrative, often avoiding inflammatory remarks that might generate more sympathy for the defendant. Instead, they may emphasize that a conviction is necessary to maintain social order, trusting that at least some jurors will view consistent enforcement of the law as the anchor of community stability. The defense perspective. Walking a tightrope. From the defense side, the possibility of jury nullification is typically more of an asset than a liability. If a defendant believes the law is unjust or that the penalties are excessively harsh, tapping into juror sympathies can offer a path to acquittal. Yet defense attorneys also confront ethical and procedural restrictions that limit their ability to openly advocate for nullification. Most courts prohibit direct statements urging the jury to ignore the law. Thus, defense strategy must be subtle and carefully aligned with legal boundaries. Storytelling and humanization. One of the defense's main tactics is to humanize the defendant, presenting them not as a mere subject who has contravened a statute, but as an individual shaped by life circumstances, relationships, or misfortune. By emphasizing personal details, family obligations, medical struggles, contributions to the community, the defense can quietly plant seeds of moral doubt in jurors' minds. Does someone like this really deserve punishment? While this approach may not be labeled nullification, It can implicitly invite jurors to weigh empathy and fairness against a strict reading of the law. Undermining the statute's rationale when permissible. Defense counsel might question or critique the rationale behind the law at issue, especially in cases involving drug regulations, excessive sentences, or ambiguous legal definitions. Without saying disregard the law, a savvy attorney can suggest that the law's purpose is ill-served by convicting the defendant. For instance, if a defendant is charged with possessing marijuana for medical use, the defense might highlight the medical community's evolving stance or the partial legalization in other states. This approach points jurors toward a conclusion that convicting does not align with broader social or medical consensus. Selective use of motions and objections. Defense counsel can also strategically shape the trial by filing motions to exclude certain evidence or objecting to prosecutorial lines of questioning, aiming to keep the narrative focused on a more sympathetic portrayal of the defendant. For example, preventing the mention of prior convictions can help the jury see the defendant as an isolated offender rather than a chronic criminal. While these procedural efforts are routine in all criminal cases, they become especially critical when the defense suspects that a morally outraged or compassionate jury might swing toward nullification if the defendant's circumstances appear compelling. Plea bargaining, the hidden arena. An often overlooked facet of nullification's impact on prosecutorial and defense strategies is plea bargaining. The vast majority of criminal cases never go to trial. They end in negotiated pleas. The knowledge that some juries might be reluctant to convict or might nullify in protest can affect the prosecution's willingness to reduce charges or offer more lenient deals. Conversely, if the state believes a jury is likely to convict despite moral questions, for instance, in areas with a law and order culture, prosecutors may feel emboldened to push for harsher plea terms. For defense attorneys, the prospect of a sympathetic jury can be a bargaining chip. They might indicate readiness to go to trial, subtly reminding the state that if the statute is unpopular or the fact pattern seems morally ambiguous, a deadlocked jury or outright acquittal could be possible. Consequently, the prosecutor may propose a less severe plea to avoid the risk of losing completely. While never openly acknowledging will nullify, this behind-the-scenes negotiation underscores how the specter of nullification shapes litigation strategy at every stage, even when the case never sees a jury. Ethical and professional constraints. Both prosecutors and defense attorneys navigate strict ethical rules, which intersect with the possibility of jury nullification in complex ways. Prosecutors are bound by a duty to seek justice, not merely convictions. If a statute appears blatantly unfair or the circumstances are extenuating, some prosecutors may voluntarily exercise discretion in charging or sentencing recommendations, thus sidestepping the scenario of a jury rebelling. On the other side, while a defense attorney is ethically obligated to zealously represent their client, they are not permitted to instruct the jury to violate the judge's directives. They must finesse arguments and evidence presentation in ways that do not overtly invite nullification, or they risk being found in contempt of court. The boundaries of argument. In closing arguments, defense counsel can point to the defendant's lack of criminal intent, question the reliability of prosecution witnesses, and highlight mitigating factors. However, crossing the line into the law is wrong, don't convict can draw immediate judicial backlash. Similarly, prosecutors must avoid suggesting that the jury should convict purely to enforce a broader social agenda. The arguments should be tethered to the evidence of specific wrongdoing. Transparency versus concealment. A broader ethical debate arises over transparency. If jurors inherently hold the power to nullify, should attorneys be candid about that possibility? Most jurisdictions answer in the negative, asserting that any instruction or direct statement about nullification is improper. This stance places attorneys in a paradoxical position. They know the jury can reject an unjust law, yet they cannot ethically encourage that rejection in explicit terms. High-profile trials and media influence. When a case garners significant media attention, whether due to the defendant's celebrity status, the nature of the alleged crime, or the broader social issues at stake, the strategies of both prosecutors and defense attorneys often shift. Jurors enter the courtroom with more prior knowledge, forming opinions before hearing formal evidence. Defense teams may exploit this environment by framing the defendant's actions in a sympathetic light through press conferences or strategic leaks, subtly priming potential jurors toward a nullification mindset. Prosecutors, meanwhile, may strive to maintain a neutral, fact-focused message, emphasizing that allowing emotion or external narratives to override legal duties would undermine the justice system. This tension sometimes spills over into court motions and orders aimed at controlling what can be said publicly. Gag orders or instructions against extrajudicial statements reflect the judiciary's attempt to keep the trial process insulated from the cacophony of media. Nonetheless, in the digital age, potential jurors can easily access social media and news commentary, even if expressly told not to, and may enter deliberations already pondering the fairness of the law itself. For both sides, acknowledging or ignoring that reality shapes trial preparations. Interplay with sentencing structures. Mandatory minimum sentences and rigid sentencing guidelines complicate prosecutorial and defense strategies related to jury nullification. Prosecutors often leverage these statutory frameworks to secure plea deals. Faced with a draconian mandatory sentence, a defendant may opt for a lighter plea rather than risk a jury trial. However, this dynamic also raises the prospect that a jury might acquit upon learning the potential penalty is excessive relative to the defendant's conduct. Defense attorneys, if permitted, sometimes hint at severe sentencing outcomes to provoke jurors' empathy. But most judges prohibit explicit references to potential sentences, precisely because they fear it might prompt nullification. As a result, both sides often operate under a cloak of partial information. Prosecutors typically avoid discussing sentencing in detail, while defense attorneys must stop short of openly suggesting that a harsh sentence should lead to a moral override. Thus, the very presence of harsh sentencing laws can subtly inflate or deflate each side's strategies, underscoring how nullification remains an unspoken but potent force. Bridging to broader social influences. Ultimately, prosecutorial and defense strategies regarding jury nullification reflect the adversarial nature of American criminal justice, with both sides maneuvering within legal and ethical constraints to sway jurors' perceptions. Yet these strategies do not exist in a vacuum. They both respond to and shape broader societal attitudes, legislative frameworks, and cultural norms. As laws evolve, whether through decriminalization movements, revised sentencing guidelines, or shifts in social ethics, the strategies on both sides will adapt accordingly. In the next chapter, we will delve further into the impact of grassroots activism, public discourse, and social movements on jury nullification. Understanding how prosecutors and defense attorneys operate in the present system helps us appreciate the friction points, where new policies or community pressures might alter the courtroom calculus. By looking more broadly at the interplay between legal actors, legislators, media, and activists, we can see how nullification serves as a bellwether for changing moral standards and a catalyst for legal reform, or for entrenched resistance to such reform. Through it all, prosecutorial and defense strategies remain the front line in the day-to-day reality of criminal trials. Whether carefully avoiding references to nullification or strategically nudging jurors' moral compasses, both sides acknowledge, in subtle ways, that the law does not exist in a moral vacuum. Instead, it is subject to the values, perceptions, and conscience of the very individuals summoned to render a verdict.